Good afternoon, everyone, and welcome to another webinar in the AlphaStaff webinar series. Today's topic is presented by Donald C. Works III. You'll meet him in just a moment. And he will be sharing with us recent employment regulations and risks, bringing us up to speed on things that have changed since our last Jackson Lewis webinar. So thank you for joining us. My name's Sandy Edelson. I'm an account manager with AlphaStaff, and probably some of you have worked with me through the years. We're going to go ahead and get started. We expect the webinar to last roughly about a half an hour to 1 hour. I think it'll be closer to the 1 hour mark. And in just a moment, there we go. We do encourage your questions. And we do have a chat feature. You should be able to see that on your screen. And if you have a question during the webinar, just type it in. We'll get to an open forum at the end today. So please, write down your questions if you don't want to use the chat feature. We are also recording, and the webinar is normally available within about 2 to 3 days on the AlphaStaff website under client resources. We do have credits for today's presentation through the Society of Human Resource Management and the HR Certification Institute. It's important to note that, pardon me, this is for the live webinar. So if you want to wait for the recorded version, unfortunately, you won't get those credits. That's how the organizations work. Don is our presenter. I think many of you have heard from Don. He's amazing. I love working with him. He is managing principal with Jackson Lewis PC Orlando office, and he specializes in all aspects of employment law, representing management, which is awesome for us who deal with employees. His bachelor's degree is in personnel management and industrial relations from the Auburn University. He does have his Juris Doctorate from the University of Miami, and he serves on many organizations, particularly the State Director of Government Affairs for HR Florida. He's a past president of the Central Florida Human Resources Association and the HR Association of Broward County. He holds his certification as a SHRM Senior Certified Professional, as well as with the HR Certification Institute. He also, in his spare time, I don't know how you have spare time, Don, but he presents and publishes articles on wage and hour and employment law topics. And he has been recognized by his peers in the publications Best Lawyers in America and Florida's Super Lawyers. So you're in for a lot of good information today. You have at your disposal today a very good attorney can answer your questions. And Don, thank you so much for joining us. I'll turn the webinar over to you now.
Well, thank you very much for the introduction, Sandy, and thank you all for joining us this afternoon for this update. We do this periodically as part of the AlphaStaff webinar series, and that is a presentation on recent employment regulations and risks. Now, the last time we did this was back in February, and you might not think much could have happened between February and now in terms of labor and employment law, but in fact there have been quite a few developments along the way. So we're going to spend between a half an hour and an hour, as Sandy indicated, probably closer to an hour, discussing what some of those developments have been since February and how they impact you as employers and what you can do to be proactive and take steps to avoid issues with your employees that could result in litigation or claims against your companies. So the developments really fall into 3 categories. First, developments with the courts, different decisions that have come down. Then we're going to talk about agency action, things that the federal agencies that govern labor and employment law have done over the past several months. And then finally, we'll talk about some hot topics and what's on the horizon for the coming year in 2019. But let's start first talking about the courts and what's new in the court system. And we'll begin with a Supreme Court update. And we've all heard a lot about the U.S. Supreme Court in the last month or two with the confirmation hearings on Justice Kavanaugh, who was sworn in recently, and we now have a full complement of justices on the Supreme Court of the United States. Prior to the confirmation proceedings beginning, however, earlier this year, we did have one session of the Supreme Court where they decided a number of different opinions or cases that have an impact on you as employers. And I wanted to spend some time talking about those. The first one is the case of Encino Motor Cars versus Navarro. It was decided in April of this year, and it dealt with the Fair Labor Standards Act. Now, most of you all know that the Fair Labor Standards Act, the FLSA, is the law that requires you to pay minimum wage and overtime to your employees unless they are qualified for one of the exemptions in the law. And the exemptions we deal with most frequently would be the executive exemption, the administrative exemption, the professional exemption, and sometimes outside sales. There are other exemptions that you may have run into: retail sales exemption, motor carrier exemption. But unless you can establish an exemption under the law, then you have to pay minimum wage and overtime. Over the years, the lower courts had developed a body of law when an employer would claim that a particular job was exempt, and that body of law gave a narrow construction to the exemptions under the law. In other words, they held that it was the employer's burden to prove they were entitled to the exemption, and that the exemption should be narrowly construed so as to further the purposes of the Act. While the burden remains the same, you, the employer, still have to prove your exemption under the law. The Supreme Court said that this narrow construction principle, the fact that exemptions should be narrowly construed, is nowhere to be found in the Act itself, and therefore courts over the years had been improperly requiring employers to prove an exemption with that narrow construction burden laid upon them. So this decision should make it easier for employers to establish that their employees are exempt under the various exemptions. All you'll have to prove is that the employees satisfy the various tests for the exemptions, and there won't be a narrow construction of the exemption held against you. So a very positive development for employers. The next decision that I'd like to call to your attention is the one in Digital Realty Trust versus Summers. In the Digital Realty case, the court answered a question that's been lingering since the Dodd-Frank Act was passed several years ago. And as you know, Dodd-Frank provides protection for whistleblowers, people who come forward and allege that there's been some sort of a violation of securities laws or banking laws. And one of the issues that we have been litigating since the law was originally passed was whether or not the individual actually has to contact the Securities and Exchange Commission to blow the whistle, or is it sufficient for them to blow the whistle internally? So any of you who have publicly traded companies, you may have had people come forward and say, we think we're doing something wrong. We're not sure this is compliant with the law. And then, unfortunately, some of those same folks may have made claims saying that they were ultimately let go because they blew the whistle in violation of Dodd-Frank. They were terminated. I personally have dealt with some claims like that on behalf of employers over the last several years. And one of the issues that keeps coming up is that enough to complain just internally? Or does the employee actually have to go to the SEC and complain in order to make a claim under Dodd-Frank? Well, the Supreme Court, again, issued a ruling that's favorable to you as employers, holding that for somebody to be a whistleblower under the Dodd-Frank law, they actually have to contact the SEC and make a complaint. It's not enough to make an internal complaint and then later try to assert protection under Dodd-Frank. So another very important decision, particularly for those of you who have publicly traded companies. Another decision that was issued earlier this year, and in particular in June, was the case of Janus versus AFSCME. And one thing that I guess has been at the forefront of union issues in the last several years is whether or not unions can charge dues or agency fees and then use those dues or agency fees to contribute to different political campaigns. And some employees, particularly in states that aren't right to work states, have said that that's not right. It's a violation of their First Amendment rights. They should not be required to contribute agency fees to a union to be used for a purpose that they might not agree with, if that would be a violation of their First Amendment rights. And in a 5-4 decision, the court ruled just that would be a violation of the First Amendment, and therefore these public sector unions can no longer force non-members to pay agency fees or dues because that would violate the Constitution. So a real blow to public sector unions and their ability to raise funds for political purposes. Other cases that have come down in the last couple months, the first one, you probably heard a little bit about this case, the Masterpiece Cake Shop case. This was a case out in Colorado where a cake shop, Masterpiece, refused to make a wedding cake for a gay couple based on religious beliefs. They had a claim filed against them for a violation of the Colorado Civil Rights Act, and that claim was heard by the Colorado Civil Rights Commission. The commission ruled against them, finding that, in fact, there was a violation of the law, but in doing so, they did not properly take into consideration the religious beliefs of the cake shop owners. They did not even the court did not reach the merits of the case, but held that the commission's failure to consider the religious beliefs amounted to a violation of the cake shop owner's First Amendment rights to freedom of religion. So they overturned the decision of the Colorado Civil Rights Commission and sent the case back down for a ruling on the merits, with the commission properly taking into consideration the defense that making the cake shop or requiring the cake shop to make a cake for a gay couple's wedding would violate the First Amendment rights of the cake shop owners. So an interesting decision, and one that shows that some state commissions get a little bit out ahead of themselves sometimes and are undermining constitutional rights, not properly considering First Amendment rights and ruling on discrimination cases. Another favorable case for employers. And then finally, we have the decision that came down in the Epic Systems case versus Lewis in May. An interesting case. Sometimes arbitration agreements, I don't know how many of you have arbitration agreements with your employees, but often they will say that you can go ahead and bring a class action, but you can't, if you've signed one of these arbitration agreements, require that arbitration be done on a class basis. In other words, if you have an agreement that says that there have to be individual arbitration proceedings, then that agreement should be enforced as drafted, and a court could not require that multiple arbitrations be consolidated into one for a class action in arbitration. So this is another case supporting your right to have arbitration agreements with your employees and putting you in a position to be able to enforce them on an individual basis and not allow employees to bring class or collective actions who have signed these arbitration agreements and have tried to proceed on a class basis. So you can see we've had 5 very significant decisions from the Supreme Court this year, all of which impact employers greatly. We've got some future cases on the horizon coming up, and these will be cases that Justice Kavanaugh will actually hear oral argument on and be a participant in issuing a decision on. The first case is, again, another arbitration type case. It's the new prime case. And the issue in the new prime case is when there's a question as to whether or not a particular claim is subject to an arbitration agreement, should that question be decided by the court, or should the court send the case to arbitration and let the arbitrator decide whether or not the claim is subject to arbitration? And there's been a split in the courts across the United States as to what way this should go, whether the court should decide or whether the arbitrator should decide what claims are arbitrable. So the Supreme Court is expected to rule on this case this year, and we'll get a better idea of just how strong the Federal Arbitration Act is. I'd say it's likely that they're going to hold that the issue of arbitrability is for the court to decide, but we'll have to wait and see. The other case that's coming up this fall before the court that's significant for employers is the Lamps Plus case. And in the Lamps Plus case, the issue goes to arbitration agreements again, and the question being whether a class-wide arbitration can be inferred based on state law, or whether it has to be specifically permitted under the language in an arbitration agreement. So this is kind of going back to the issue that arose in Epic Systems, like, do we have arbitration agreements that are to be enforced on an individual basis, or should they be on a class basis? And whether or not the court would decide that or an arbitrator would decide that. So the Lamps Plus case will be very significant in terms of arbitration agreements as well. And before we move on, you see 3 out of the 8 decisions or cases that I've talked about thus far deal with arbitration. This is becoming more and more of an issue for employers. Those of you who have arbitration agreements probably recognize that the primary benefit is that you get cases away from a jury and they're decided by an arbitrator or a panel of arbitrator. And typically the arbitrators or the panel have more knowledge of employment law and issues related to employer-employee relations. That can be a good thing to get things away from a jury. For years, people thought that arbitration was a lot less expensive than litigation. That's simply not the case. There's just as much discovery done in arbitration, and it's just as expensive as litigating in the court system. However, there remains that advantage of getting a case away from a jury where results are often very unpredictable. So if you're using arbitration agreements, I'm sure you know the advantages. If you're not, given all the favorable decisions that are coming down from the Supreme Court, it may be time for you to look at arbitration, maybe talk to AlphaStaff, and decide whether or not that's something you want to consider going forward for your employees. Finally, with regard to future cases before the Supreme Court, there was one case that came up called the Severson decision, or the Severson versus Heartland Woodcraft, and it's in the next slide there, Sandy. And in Severson, the issue is one that we've been dealing with for years now, and that is under the ADA, when somebody exhausts their FMLA leave, do you have to give additional leave as a reasonable accommodation under the ADA? And there had been a Seventh Circuit Court decision that held that 2 to 3 months of leave after an employee already exhausted their FMLA was not a reasonable accommodation. And the court noted that the ADA was intended as an anti-discrimination statute, not a leave entitlement statute like the FMLA. Similar cases have come down from the 10th and the 11th Circuit. And what the Supreme Court did is they said, look, there's no conflict here. The courts that have ruled are in agreement, so we're not going to take this up on appeal. But it's interesting that they did not find it important enough to consider or try to overrule these decisions. Somewhat of an indication that extended leave may not be a reasonable accommodation that's required by the ADA. So a little bit more support for employers in that regard. So as you can see, there's been a lot happening at the court level, things that would impact employers in the United States. At the agency level, there have been a lot of new developments as well. Now, I guess it probably won't come as any surprise to you all that the agencies, the EEOC, the National Labor Relations Board, do not yet have their full complement of members, because members that left with the last administration left positions vacant, and the Senate has yet to confirm people to fill those vacancies. What are we, almost 2 years now, these vacancies have existed. That being said, the agencies have gone on without their full complement of members at the helm to issue guidances and regulations that impact you as employers. The first one I'd like to talk briefly about is this new EEOC guidance on harassment, and it's what they call promising practices for preventing harassment. This is just what it sounds like. It's a guidance, it's not law. But it is something that employers should take into consideration, because when you get a claim of harassment filed against you or a charge of harassment filed against you, that claim will be considered by the Equal Employment Opportunity Commission. And if you've handled matters in a manner that is consistent with their guidelines, they're more likely to rule in your favor in connection with that particular claim. So you always want to consider these guidances, even though they don't have the effect of law, in making decisions with regard to your workplace. So what is this new guidance all about? The core principles, as you can see on the next slide, are, number one, they want to see that you have engaged leadership, that your upper level management is committed to preventing harassment in the workplace. And that can be shown a lot of different ways, maybe town hall type meetings where management speaks and vocalizes the commitment that the company has. It can be expressed through your policy, but they want to see that leadership is committed and engaged to prevent harassment in the workplace. They also want to see accountability. So when management or others in power don't uphold the law, don't eliminate harassment, don't take complaints seriously, those people need to be held accountable, and that could be through appropriate discipline. So that's something that the commission is encouraging. Not surprisingly, they want you to have strong and comprehensive harassment policies. And if you don't have those in place already, I'm sure AlphaStaff can help. Next, they want you to have what they call trusted and accessible complaint procedures. And those would be like an 800 number, maybe an internal hotline, maybe several different resources within your company to whom people could go to make a complaint. And then finally, they want to see that you have regular interactive training that's tailored to the audience, be it management or the employees, on harassment in the workplace and how to eliminate harassment and retaliation for complaints. So this is a new guidance out of the EEOC. One of the things they've been doing, even in the absence of their full complement of members. Now, over at the National Labor Relations Board, there's also been some action. And one of the things that they have done recently is they've released a proposed rule on the issue of joint employer status. Under President Obama, the National Labor Relations Board had held that if a company retains indirect control, contractually reserved control, or had limited control over employees, then they would be considered a joint employer. And this is particularly important with staffing companies that you might use, or even independent contractors that you all as businesses contract with. This issue of who is actually the employer continues to come up. And under the Obama era expansion, the law was held to cover both the primary employer and these other entities that were only tangentially involved in the employment relationship. So the NLRB, through this proposed rule, is seeking to overturn those decisions and hold that somebody would be considered a joint employer only where they actually exercise control over the terms and conditions of an employee's employment. So this is what's going on at the NLRB. Very positive for employers, both primary employers and secondary employers, to get this issue resolved, because it lends itself to a lot of different interpretations, and there's always a lot of questions when claims arise as to who's responsible. So the board hopefully is going to help us resolve some of those issues. So as you can see, not only at the court level, but also at the agency level, we've had a number of different developments. In the meantime, there have been what we are considering hot topics, things that we as attorneys at Jackson Lewis continue to encounter and have to deal with on a day-to-day basis in working with our clients, issues that keep resurfacing. The first one would be how to navigate new hiring rules. And this is very important, particularly in this economy. We have an economy where unemployment is extremely low, and you all know how difficult it is right now to find new employees. So to the extent that restrictions are put on you as employers on how to go about finding new employees and hiring new employees, those restrictions make it all the more difficult to fill positions that you're already having a difficult time filling. So let's talk about some of those restrictions that we're having to deal with. One of them are ban the box laws. And you all are probably familiar with this. Basically, for years on employment applications, employers would have a little box that the applicant would check yes or no, whether or not they had ever been arrested or convicted of a crime. There are a number of states, you can see 11 states now, and 17 different localities that have held that you cannot have that question on your applications. So you can't even ask about it on your applications. Now, in those jurisdictions, companies that cannot ask the question on their application many times are using background checks, and they're doing those checks in accordance with the Fair Credit Reporting Act, because the Fair Credit Reporting Act governs not only background checks into credit, but also background checks into criminal history. One thing that I should point out to you is effective September 21st, when you're doing a background check under the Fair Credit Reporting Act, you have to get consent from the applicant. And then if you find something adverse, you have to give them a pre-adverse action notice. And then finally, if you decide not to hire them, you have to give them an adverse action notice. With those notices, you have to give the employees a summary of their rights under the Fair Credit Reporting Act. That summary was revised in the last couple of months, and it went into effect almost immediately, that this law that you had to start providing that new summary of rights. So if you are doing background checks and you are complying with the Fair Credit Reporting Act, you need to double check to make sure that the summary of rights that you're distributing is the updated one, the new one that was enacted approximately a month ago today. Other things that we're seeing in the hiring arena, issues with regard to social media searches. I don't know about you all, but I know that many employers that we deal with are doing searches of social media before they're extending offers to potential applicants. And they're looking for information that either supports or contradicts what the applicant has told them. They want to see some personal information, and in particular professional personal information online, like on LinkedIn. to see if their job history matches what they have represented it to be, or their experience represents what it was supposed to be. The only caution is that you should not be using applicant usernames or passwords or trying to determine what those are, or friending people on Facebook in order to do these searches. There are possible claims of invasion of privacy if you are using usernames or passwords or obtaining them improperly. So a little cautionary note in the social media arena. Another issue we're seeing with respect to hiring is this whole issue of, can you ask about the applicant's prior salary? For years, employers have asked during interviews, how much are you making now? What are your salary expectations? And they've asked those questions to find out the level at which the person's currently being paid so that they don't overpay them or make an offer too generous. I mean, why would you want to pay more than you had to? So those questions for years have been asked, and recently we're seeing some restrictions on A, whether you can ask the questions, and B, what can you do with the information, or can you even rely on it when you get that information? One thing that's come out most recently from the Ninth Circuit Court of Appeals, which is based in California, is that under the Equal Pay Act, one of the defenses to a violation of the Equal Pay Act has always been the employer has to point to a factor other than sex, something other than sex, as justification for women having lower salary than men, or men having lower salaries than women. For years, employers have said, well, we base the salary upon what their prior salary was. The Ninth Circuit has said you can't do that. That's not a justification for a lower salary, because the effect of doing that is to perpetuate discrimination in pay against women. States have jumped into this arena as well and started to ban employers from even asking the question about what a person's prior salary was. And you can see the list of those states there, and also some municipalities and also Puerto Rico that have similar bans. So in those jurisdictions, you cannot ask the question about what somebody's salary history is. And in other jurisdictions, even if you ask the question, you're not going to be able to use the information as a basis to pay women less than men in violation of the Equal Pay Act. So these restrictions, these questions about pay history, social media searches, ban the box laws, are making it even more difficult for employers to hire in an already difficult environment where unemployment is so low. Things you need to be aware of, though, and laws that you need to be compliant with. Other changes we're seeing in the workplace and adaptation we have to deal with is dealing with these new drug laws. You probably heard on last night's news the fact that Canada has now legalized recreational use of marijuana. It's going to be sold by the government and it's going to be taxed, but it is completely legal now to use marijuana for recreational purposes throughout the entire country of Canada. They are now the largest country that permits recreational use of marijuana. You can see in the next slide that the support for legalization in America is up. Right now, the polls show that 61 to 63% of Americans support legislation that legalizes marijuana. Nearly half have actually tried marijuana. More and more states are legalizing it, both on a recreational basis and also for medical purposes. And there's even bipartisan support. I know that's shocking for anything nowadays, but there's really bipartisan support to defer to the states and not enforce federal drug laws that prohibit marijuana use. So right now we're seeing a trend in our country that would permit more use of marijuana, similar to what's going on in Canada. As you can see in the next slide, there are already a number of different states that have permitted recreational marijuana use. They're in blue there on the left-hand side. And then in addition to those states, we have 15 more states that allow the use of low THC products for medical reasons or to provide a legal defense to claims. So the trend is definitely toward permitting more use of marijuana for in the United States. This is presenting issues, legal issues for employers. As you can see in the next slide, one of the issues that has continued to come up or is coming up is whether or not, let's say you do pre-employment drug testing and the person tests positive for marijuana. What if they have a prescription? Can you refuse to hire the person who tests positive? There are at least 4 states that now say you can't refuse to hire them as long as they have a medical marijuana prescription. You would still have to hire them if they have a pre-employment test that comes back positive. Only one state, Colorado, has said that if somebody tests positive, you don't have to hire them. So that's something you're going to have to wrestle with if you're doing pre-employment drug testing. Somebody comes back positive for marijuana, do they have a prescription? And can you deny employment if they do? It's interesting to see the number of positive drug tests that are coming back positive. The statistics in the next slide are somewhat disconcerting. What we're seeing is 5% of the general workforce now is testing positive for drugs. And 2.1% of the workforce that test positive are in safety sensitive positions. So that would be like drivers, pilots, air traffic controllers. To me, very disconcerting to see that rise. There's a 4.2% combined rate of positive drug tests in the general workforce, which is up from 3.5% in 2012, and that was a 30-year low. But it shows that, I guess, in part due to these changing laws, we're seeing more and more positive drug tests. There has been an upward trajectory in marijuana use, a sharp rise in use of methamphetamines, in particular in the Midwest and the South, and cocaine rates have increased for 5 consecutive years now. We have seen a decline in opiates, and that's something that, as you all know, the federal government has been focused upon. But these other trends are disconcerting, and what's troublesome for employers is not just that people are testing positive, but there are more and more restrictions on what you can do about it in light of the laws that make some drug use legal. All right, so I've already talked about how we have low unemployment, and wage pressures. One of the things that's causing raised pressures, as you can see in the following slide, is that starting pay has really been on the rise. And that's in part due to the fact that minimum wages have been going up. In 13 states, minimum wage is $10 or higher, and 9 states are set to go even higher. And you can see a chart there where a number of different states are going up to $15 an hour. There are similar proposals to that in other states. One that's not on here is Florida, where year after year there's a bill introduced that would increase the minimum wage up to $15 per hour over a 3-year period. It would be tiered or staggered, but we're definitely seeing an increase in minimum wage. The other thing we're seeing is that employers themselves are deciding that they're going to voluntarily increase their minimum wage. We heard recently that Amazon had adopted an across-the-board minimum of $15 an hour. So that's raising starting pay across the board and is putting wage pressure on other employers, making it even more difficult for you to find and hire new workforces. You can see that in the next slide, the pay raises that have gone up slightly from 2.8% a year to 3.1% a year this year. And it's expected that the range is going to be from 1 to 4.6% based on work performance. So we expect continued wage growth, and that has implications for the job market as well. The graduates from the class of 2017 certainly did better than their predecessors who were having trouble even finding employment. You can see here that the average salary coming out of college in 2017 was $50,500. And the range was anywhere from 52 all the way up to 72,000 right out of school after a 4-year degree. So definitely some positive developments, especially for you parents out there who have kids graduating from college right now. All right, another issue that's been a hot button for a couple of years is this issue of the overtime pay rule. This goes back to the exemptions I was talking about earlier. Under the Fair Labor Standards Act, for somebody to be exempt from the overtime requirement of the law, you have to prove that they satisfy certain tests. They have to be either an executive, administrative, professional, employee, and each of those exemptions requires that the person be paid on a salary basis. Currently, the minimum salary is $455 a week, which is only $23,600 a year. It's quite low. Can you imagine an executive employee who's paid $23,600? I don't think so. Under the Obama administration, you might remember that they tried to change the rule. They were going to raise it to $913 a week or $47,000 a year. An injunction was issued by a Texas district court that's still pending on appeal, but that never went into effect. Presently, the Wage Hour Division is looking at proposed regulations that would implement a new salary basis for the exemptions of $615 a week, which is like $32,000 a year, something that's a little bit more realistic. And you would have to establish that the person made that in order for them to qualify for one of those white-collar exemptions. In the final rule that they issue, probably later this year or early next year, there may be different salaries for different regions as well. That was one of the main problems that was pointed out with the Obama administration's rule, was that $47,000 a year in some parts of the country was quite high. And it would make it very difficult for employers to continue to employ people in those positions. So one of the things we may see in a new rule are some geographic differences. Some other hot button issues, things that have come about and continue to be an issue, this issue of how do you manage leaves of absence. I mentioned earlier that Supreme Court case where they denied cert on a case where the issue was whether or not extended leave had to be granted under the ADA as an accommodation. That continues to be an issue. Also in connection with leaves of absence, whether you pay them continues to be an issue. You can see here, employers generally provide paid vacation, sick leave, and many provide personal days. But you're seeing a rise in the number of employers who also have paid maternity, paternity, adoption leave, and foster care leave. All of these additional benefits being thrown at the workforce to try to attract new employees, and also making it more difficult for those of you who don't have those benefits to attract new employees. In addition to the voluntary programs that you see here that employers are adopting, there are a number of different states and municipalities that are mandating paid leave. You can see lists of them here. And these are laws that require paid leave in the private sector. If you are a national employer, you can imagine how difficult it is to develop a universal policy that conforms to all of these different state and local laws requiring paid leave. What we are seeing many national employers do is to basically lump all of the leave into one bucket, and the amount being dependent upon the jurisdiction they're in, but not necessarily categorizing it as maternity, paternity, adoption, vacation, sick, personal, but just having one bucket of PTO to be used in accordance with the local and state laws. So this is something that a lot of employers are wrestling with, and something which I'm sure that if you're working to develop a policy like that, you could work with AlphaStaff and they would be of great assistance in that regard. One thing I'll mention finally with regard to leaves, you can see in the next slide, there are a number of states that actually have paid FMLA as well, and a number of others coming on board in 2019, 2020, and then 2021. So additional laws that you're going to have to be compliant with. The last thing I'd like to talk about would be the responding to workplace complaints. And in particular, how do we deal with the Me Too movement? What we're seeing is employees coming forward and they're claiming for the first time that they have been sexually harassed, sexually abused, and they're making those complaints. In dealing with those complaints, first thing you need to think about is how are we going to answer to the EEOC if we get a claim? And you can see in the next slide something I alluded to before, which is the EEOC doesn't even have its full complement of members now. There's still 2 people whose nominations are being held up in the Senate. I will say, though, even with the new members, I don't think their focus is going to change too much. And in fact, they've been very focused on unlawful harassment, and particularly in light of the Me Too movement, will continue to be supportive of claimants in that regard. Some of the issues that await the new EEOC commissioners when they come on board, you can see in the next slide, they're going to be considering wellness rules, whether to expand the EEO-1 reporting requirements to include pay data, which they had proposed before, and you can see that in the next slide. And then finally, they're going to be looking at civility rules. And these civility rules will deal with Me Too issues and also will deal with bullying issues. Many states have been enacting anti-bullying laws, and so the EEOC, working with the National Labor Relations Board, has decided that they're going to try to develop some sort of national civility rules. So the days of my advising that as long as the person is an equal opportunity harasser, there's no legal problem, those days may be short-lived. Looks like under the new civility rules, even an equal opportunity harasser will have trouble under the law. And finally, one of the things I wanted to mention in this regard is when you're dealing with complaints under the Me Too movement, there are some rules you have to follow, depending on whether you're a union employer or you're a non-union employer. Ones that I'd like to point out is with union recorders or union investigations, they have the right to have a representative present, but they don't have the right to record the meeting. And you cannot tell people to keep the meeting confidential. The same is true with non-union employers. A no recording rule would be lawful, and you cannot tell people to keep things confidential unless you could show that witnesses need protection or there's some danger to evidence. The reason being, employees have the right to discuss wages, hours, and other terms and conditions of employment. So if you tell them not to discuss what's going on with an investigation, you have impinged on their Section 7 rights under the National Labor Relations Act. So when you get these Me Too complaints and you're doing your investigations, be careful to follow these rules. Now, when you get those complaints, you investigate, many times you'll take appropriate action, but the employee or former employee may want to settle up with you on a claim that they may have. And as you can see in the next slide, there's some tax issues with regard to those settlements. This was one of the things that was buried in the Tax Reform Act earlier this year when we got our tax cuts in 2018. There's a little known provision in there that says if you're settling a case that alleged sexual harassment or sexual abuse, and you include a provision in the settlement agreement that the person cannot disclose the settlement and that they have to keep it confidential, then that settlement is no longer tax deductible. And you cannot even deduct the attorney's fees spent in connection with the settlement. So this was put in there to discourage employers from basically burying these claims and keeping them from coming to light, to encourage more people to come forward as part of the Me Too movement and articulate concerns about the workplace. All right, I'll just go quickly through the next several slides. I don't know how many of you are union employers, but there have been basically a real downturn in union membership. In the public sector, you can see in the slide that's before you now, this goes back to that Janus decision that I mentioned earlier. Because they can't collect agency fees, there definitely is going to be a decline in their income and membership. The next slide shows that right to work states where people don't have to join a union in order to be employed at a particular employer, the number of right to work states are on the rise. And then you can see in the next slide that the board is moving to the right, will be much more employer friendly. Some of the things that we expect them to deal with in the final slide, you can see are union election rules, the use of employer email, whether or not employees have the right to use the email and whether or not you can monitor it. And then, as I mentioned earlier, the joint employer rules and limiting the Brown-Ferris decision. So a lot's going on the union front as well, but generally on the decline. I read an article just the other day where former Vice President Biden was mentioning the fact that unions were on the decline, and that was something that he believed a stronger NLRB could change. So political implications here certainly, but definitely implications for you all as employers. Non-union, you don't have to worry as much about organization. Union employers, maybe a chance to achieve decertification of your union. So to conclude, well, it seems like there's not a lot happening on the employment front. There has been a lot happening. It's just been in the shadows. Agencies have been dealing with things. State and local governments have been passing various laws. And you as employers need to stay abreast of these changes. I would encourage you to work with AlphaStaff to do just that. And we'll be happy to answer any questions now or hereafter. Thank you for your time today.
Thank you, Don. I'm not seeing any questions in the chat feature, but I'm going to open that up just to make sure. And I do not see any questions. So,
okay.
So Don, I want to thank you again, and everybody attending, thank you for taking the time. And just as Don said, please reach out to your HR account manager if you have any questions. Just to close out today, and by the way, Jackson Lewis, you guys have an amazing baseball cap that I get every year that says always work. So if anybody is ever at a conference and Jackson Lewis is there, you can scoop one of those up.
Folks have been collecting them for years.
I have about 8 different colors. So yeah.
Great, great.
So thanks. If you're interested in getting a copy of the presentation, you can reach out to the HR Service Center, which is hrsc@alphastaff.com. Call us, contact your HR account manager in any way. Just let us know that you would like that. And I also want to encourage you to mark your calendars for next week, October 25th at 2 p.m. Two of our risk management specialists and strategists, if you will be presenting reducing and managing workplace injuries. One more thing as a employer that you have to think about. So don't miss that. And again, I thank everyone. Have a great day.
Thank you, Sandy. Thank you, everyone. Bye-bye.
Bye-bye.